Imagine this. A local political drama gets so tangled, it actually lands in the High Court. You've got a political party saying its own representative wasn't really ever a member, and crucial paperwork seems to have just sort of vanished into thin air. Now, this isn't just about one person losing their council seat. It really goes to the heart of how political power works, or sometimes doesn't, and the actual rules meant to govern our democratic process. So today we're giving you a front row seat to a really fascinating legal fight from South Africa. It's the High Court case of National People's Party v. Municipal Manager, and the judgment came down in March 2016. Our mission here is to unpack this pretty complex legal deep dive. We want to lay out the surprising facts, shine a light on the key legal questions, and show you what it all means for how municipalities are run. Think of it as your shortcut to understanding a case that's, well, more dramatic than it sounds and actually quite relevant.
And just so you know, our main source for this is the High Court judgment itself. Justice Bokwana delivered it, and it gives us a really detailed, step-by-step account of the whole dispute. It's how we can see how the court picked apart this pretty unusual situation.
Okay, let's dive right in then. The core conflict, who were the main players, and what exactly was the fight about?
Right, so the applicant was the National People's Party, the NPP. They took the municipal manager of the Witzenberg Municipality and also the Independent Electoral Commission, IEC. They took them to court. And what they fundamentally wanted was for the court to say, look, this guy, Mark Anthony Mentor, he's the third respondent, was not a legitimate member of our party, and therefore he couldn't be a councillor representing us.
So basically, the party itself was saying, this person sitting in our designated seat isn't actually our person.
Exactly that. And they came at it from two angles. First, they said, well, Mentor was never actually an NPP member, so he had no right to the seat from the get-go. Second, they argued, okay, even if somehow he did become a member, that membership automatically died the minute it was clear he was also a member of other political parties. They pointed to a clause in their own NPP constitution that strictly forbids that.
You know, what's really striking there is how it immediately throws into sharp focus that fundamental principle, especially in partyless systems like South Africa's. Yeah. A councillor's position, their legitimacy, it's tied directly to being a valid member of that party.
Absolutely. If that connection is shaky or just plain wrong, it really can undermine public trust in who's representing them.
Okay, so the NPP has this issue. They go to the municipal manager and say, declare a vacancy, but then comes the roadblock. The manager just refused. Why was that refusal such a critical point?
Oh, it was the whole reason it ended up in court. The law, specifically the local government. Municipal Structures Act has procedures, right? If a seat becomes vacant, the municipal manager has to tell the IEC. Then the IEC steps in to fill the seat. By refusing to declare that vacancy, the manager basically stopped the whole process cold, created a bottleneck. The NPP felt they had no other option but to go to the High Court to force the issue.
Got it. And just a small side note, you mentioned Mr. Mentor, the councillor at the center of it all, actually appeared in court himself.
Yeah, he represented himself, told the judge he couldn't afford lawyers. Adds another layer to the situation, doesn't it?
It certainly does, so that sets up the court case. But how did Mentor even get into that council seat? What's the backstory that led to all this controversy?
Right, let's rewind a bit. This goes back to early November 2015. The NPP president at the time, Mr. Badi Chaban, resigned. His daughter, Wisali Chaban, took over, leading the party. Then, very shortly after, like in the first week of November, there's this meeting. It's Chaban, the former president, Mentor, and another guy, Andre Jacobs. Now, Jacobs was the leader of a different party, the Nationalist Colored Party, or NCP.
Okay, so you have the ex-NPP leader, the leader of the NCP, and Mentor, the guy who ends up in the MPP seat. What happened at that meeting?
Well, they agreed Mentor would replace Chaban as the NPP councillor. But here's the really crucial part. It was common cause, meaning everyone involved agreed that Mentor was not an MPP member at that specific moment.
Wait, hang on. He wasn't a member, but they agreed he'd take the MPP seat. How does that even work? Was the plan for him to join?
That seems to have been the fuzzy idea. The thinking, apparently, was that he'd represent the interests of both the NPP and Jacobs' party, the NCP.
Someone representing two parties from one seat. That sounds problematic from the start.
So the membership issue, how was that supposed to be sorted out? Or wasn't it?
And that's where the stories completely diverge. Mentor claimed Chaban gave him an NPP membership form right there at the meeting, which he says he signed immediately. He also claimed Chaban emailed him an official Appendix 4 IEC form, but the NPP, they strongly denied all of it. Said he never signed anything, was never given a form, and definitely wasn't emailed that IEC document. the total contradiction.
And then the actual nomination form goes to the IEC, putting Mentor in the seat. This was dated November 6th, and it was signed by Andre Jacobs, the NCP leader.
Yes, signed by Jacobs. But the NPP argued Jacobs had absolutely no authority to sign anything on their behalf. They said only Chaban, the new leader, could do that. They basically called Mentor's nomination a mistake made by Jacobs, who, they claimed, didn't even bother checking if Mentor was actually a member. It really does raise a big red flag about, internal party controls. How can someone get nominated for public office representing a party without anyone confirming they're actually in the party?
It points to a serious potential gap, doesn't it? A lack of basic checks and balances that could really undermine the whole system of representation if it's widespread.
Then things apparently got even uglier. There were allegations of extortion.
Yes, quite serious ones. Mentor claimed that later in November, Jacobs demanded R10,000 for the NPP. Mentor said he refused. Then he alleged Chaban herself called him, demanding R13,000, and threatened to basically fire him as councillor if he didn't pay up.
Wow.
And it didn't stop there. Mentor claimed the demand then went up to R22,000 if he wanted to keep the seat until January. He said he reported this to the police.
And Chaban's response?
She denied any extortion attempt. Her version was that Mentor had offered to resign because he was having financial problems. So completely different stories again. It certainly escalated things.
Definitely. And throughout all this drama, the municipal manager is still refusing to act.
Still holding firm. Even when Chaban and her daughter emailed him formally in early December, stating Mentor wasn't an NPP member and asking again for a vacancy declaration, he refused. His main reason, as you said, was this very narrow reading of the law. He insisted the act only talked about a councillor ceasing to be a member, not someone who had never been a member in the first place.
Which seems like a technicality that ignores the substance of the issue?
Precisely. The NPP's lawyer tried engaging with both the manager and the IEC. But the IEC just repeated their position. They couldn't do anything until the municipal manager officially notified them of a vacancy. Complete stalemate.
And then there was that bizarre twist where Mentor actually did resign.
Yeah, very briefly in December 2015, he submitted a resignation. But then just a few days later, he sent another letter withdrawing it, claiming he'd only resigned because Chaban had insulted him. So a very short-lived resignation.
Okay, so that covers the was he ever a member argument. But the NPP had a second major point, right? About dual membership.
Correct. Their constitution, Clause 12.8.2, apparently prohibited members from belonging to other political parties simultaneously. And the NPP argued that even if Mentor somehow qualified as an NPP member, he was definitely violating this rule.
What was the evidence for him belonging to other parties?
The NPP claimed he was still leading his own party, the Democratic Association of Witzenberg Independence, the WOI, and was also a member of another one, the Voice of Independence Party, or VIP. So potentially involved with three parties at once.
And Mentor's defense against that claim?
He argued Chaban knew he was a VIP member when they first talked. He also claimed he'd resigned from VIP since then. But, and this is critical, he didn't provide any date for this supposed resignation or any proof it ever happened.
Right. A claim without evidence is, well, just a claim, especially when the NPP apparently had counter-evidence.
They did, and it seemed pretty strong. They got an affidavit from a VIP leader, John Vischini. Vischini stated under oath that Mentor was a VIP member from November 2015 onwards and had never resigned in writing, which the VIP Constitution required.
And Vischini provided documents.
Yes, he included an annual membership form for Mentor from September 2015 and VIP candidate lists from September-October 2015, both showing Mentor's name. Strong indicators of ongoing membership right around the time he became an NPP councillor.
But wasn't there one particularly damning piece of evidence regarding VIP?
Ah, yes. Probably the most compelling bit was an email from Vischini to Mentor, dated December 9, 2015. Remember, this is while Mentor is supposedly serving as an NPP councillor.
Then what did the email say?
It informed Mentor that he'd been appointed as deputy leader and chairperson of a newly formed executive within the VIP.
Wow. So not just a member, but being appointed to a leadership position in another party while holding the NPP seat.
Exactly. It strongly suggested his active, ongoing, and significant involvement with VIP.
You know, linking this back, it really hammers home that core idea in our party list system. You're elected under a party banner. The expectation is loyalty to that party. Being actively involved, let alone leading in another party simultaneously. It fundamentally challenges who you're representing.
It really does. It puts the whole basis of that representation into question. This case became a real test of that principle.
So With all these conflicting stories, the membership questions, the dual allegiance evidence, how did the court actually go about sorting it all out and applying the law?
Well, the MPP leaned heavily on specific parts of the local government, Municipal Structures Act. Section 27C is key. It says, a councillor elected from a party list loses their seat if they cease to be a member of the relevant party.
Okay.
Then there's Schedule 1 of the Act. Item 10.1 says only a party can submit a list of candidates. And Item 18.1b says the municipal manager must tell the chief electoral officer within 7 days if a councillor, for any reason, stops holding office.
Right. So that brings us back to the municipal manager's interpretation of ceases to be a member. That was the logjam. How did the court view that specific phrase?
This is where the legal reasoning gets interesting. The judge didn't just take the words literally. They used what's called a purposive approach to interpreting the statute.
A purposive approach, meaning?
Meaning, you look beyond just the dictionary definition of the words. You ask, what was the purpose of this law? What was Parliament trying to achieve when they wrote it? The court recognized that the whole system of party list representation hinges on councillors actually being members of the party they represent. So the judge reasoned that interpreting ceases incredibly narrowly to only mean someone who was once a member and then stopped would lead to an absurdity.
How so?
Because it would mean someone put on a list by mistake, or maybe even through fraud, could just stay there indefinitely because they never technically ceased being a member, simply because they never were one. That clearly wasn't the law's intention. The purpose was to ensure genuine representation linked to party membership.
That makes sense. So the court looked at the spirit, not just the letter of the law. How did they then decide the factual question, was Mentor ever actually an NPP member?
Here, the judge took what was described as a robust common-sense approach. They acknowledged Mentor didn't have a lawyer, but looked squarely at the evidence presented.
And the evidence against his membership claim was?
Pretty overwhelming, frankly. He couldn't produce that membership form he claimed to have signed, couldn't explain where it was, even after a formal request from the court. That's a big red flag.
Definitely.
Then there was that WhatsApp message from Chavan, the one saying, "You not a member, Mark. Did you join NPP? When? I never saw your membership card." That directly supported the NPP's version of events.
Right.
Plus, there was zero evidence he'd ever paid any membership fees to the NPP, which you'd normally expect. So, weighing it all up, the court found in favor of the NPP on this point.
So the court's finding was clear: Mentor was not an NPP member.
Correct. The court accepted the NPP's version of the facts on that crucial issue.
Okay, and what about the second argument, the dual membership? The NPP Constitution Clause was called ambiguously framed. How did the court handle that?
Yeah, the wording wasn't perfectly clear. But even so, the court accepted the NPP's interpretation that belonging to another political party automatically terminated NPP membership under their rules. And this principle that joining another party can automatically end membership in your current one isn't novel. It's been dealt with in other cases. Sometimes it happens automatically without needing a whole disciplinary hearing process. The act itself triggers the consequence according to the party's own rules.
And the evidence strongly suggested Mentor was active in VIP while holding the NPP seat, including that leadership appointment.
Exactly. The evidence showed he became an NPP councillor while seemingly still a VIP member. And his VIP involvement didn't stop. It arguably increased.
Did the judge comment on anything else unusual?
Yes. Interestingly, the judge did note how strange it seemed that Andre Jacobs, the leader of the NCP, was so involved in NPP internal matters, like nominating Mentor. The judge felt it seemed in conflict with the NPP's own rules against dual membership, but stated that Jacobs' role wasn't the specific legal question they had to decide. The judge also mentioned the lack of clarity around Mentor's very brief resignation and then its withdrawal, just added to the overall slightly chaotic picture.
So after weighing all the evidence, the arguments, the law, what was the final clear ruling from the High Court?
The court was unambiguous. It found that Mentor is not entitled to occupy the seat as a councillor representing the NPP in the council.
And the specific orders given?
Two main things. First, a formal declaration. Mark Anthony Mentor was not a member of the NPP. And flowing from that, he was accordingly not a councillor of the Witzenberg Municipality.
So he was out. Was there anything about legal costs?
Yes, and this is quite telling. The court ordered no costs award, meaning Mentor didn't have to pay the MPP's legal fees. The judge specifically acknowledged his financial situation representing himself and noted that while his opposition failed, it wasn't entirely unfounded or frivolous given the messy facts.
Okay, so stepping back, what are the big takeaways from this case? What does it all mean for you, the listener, and for how local government works?
Well, I think it sends a really clear message. First, counselorship in this kind of system is absolutely dependent on having a valid, ongoing membership with the party you represent. That link is non-negotiable. Second, it clarifies the duty of officials like the municipal manager. They must declare a vacancy if someone isn't entitled to the seat, whether they cease to be a member or, as in this case, never were one to begin with. You can't hide behind narrow interpretations to avoid action.
So it reinforces accountability.
Exactly. It also underlines how important it is for political parties themselves to have clear constitutions and, crucially, to actually follow their own rules for nominations and membership. Procedures matter. And maybe most broadly, it shows the judiciary playing its role, looking at the purpose of laws to ensure democratic processes aren't undermined by technical loopholes or, frankly, administrative failures, upholding the integrity of the system.
And didn't the judge add a final, quite pointed thought in the judgment itself?
Yes, a worrying observation,
Yes.
as the judge put it. They remarked on the seemingly casual way counselorship was just sort of given to someone who wasn't even a member, apparently by a resigning party president, without proper internal party checks. It really highlighted a potential lack of oversight.
So this deep dive into National People's Party v. Municipal Manager really shows how what seems like a simple question, is this person a member, can blow up into a complex legal fight with pretty big consequences for local politics. We've seen the court really digging into the purpose behind the law, not just getting stuck on specific words, to make sure the outcome reflected the law's actual intent.
Absolutely. And the case hammers home that vital connection between a political party and the people elected under its name. It's a reminder that clear rules and actually sticking to them are fundamental for local democracy to function properly. These seemingly small cases, often carry really significant principles about governance.
And here's something for you to think about. This case really makes you wonder, doesn't it, about the internal machinery of other political parties, not just in South Africa, but anywhere. How careful are they really in making sure their representatives are properly affiliated and truly committed to the party mandate? What other mistakes or maybe deliberate ambiguities might be lurking in political appointments? And how could those potentially affect the communities those representatives are meant to serve? Definitely something to chew on until our next deep dive.